Welcome to the burglary tutorial, and in this tutorial I'll be taking you through the law relating to burglary. So first of all, we find the law under section 9 of the Theft Act 1968. So in our previous tutorial we reviewed the area of theft, which was covered in sections 1 to 7. You may want to look at the Theft Act, which you can review under legislation.gov.uk to review these sections in more detail. The missing section, section 8, will be covering robbery. Section 10 covers aggravated burglary, but it's not one that you need to learn in particular for the A level, but I will just briefly talk you through that at the end. Burglary, defined and covered in section 9 of the Theft Act. The most important thing to realise about burglary is that there are two types, and not a lot of people know that, and also not a lot of people would know that burglary is more than just breaking and entering somewhere and stealing. It is wider than that, so hopefully you'll get a lot out of this tutorial. So the two types are covered, as they say here, under section 9, subsection 1, subsection A, and section 9, subsection 1B. So we're going to look at those two types. And what you should do for your own notes is make sure that you write the law for each section into a table. So section 9(1)(a) is where he or she enters a building or part of a building as a trespasser with the intention to steal, inflict grievous bodily harm, or cause criminal damage. Section 9(1)(b) is where he or she has entered a building or part of a building as a trespasser and then goes on to steal or attempt to steal or inflict or attempt to inflict grievous bodily harm. So review these two sections as far as we have come and see if you can identify what the actus reus and mens rea are within these offences. So actus reus being the physical part of the crime, and of course mens rea being the relevant state of mind. And then secondly, see if you can actually identify the difference between these two types. So pause here and do that, please, and then we will go on to talk about the difference. So the really important thing is that section 9(1)(a) is not a complete offence. It does not require a defendant to have stolen or even attempted to steal or commit criminal damage or inflict grievous bodily harm. This is all about the intention of the defendant at the time of entry. So you could be standing outside a shop and think, I want to go in and steal something. You walk in that shop and you have that intention to steal, but something happens that makes you perhaps walk back out again, or perhaps somebody stops you and you're unable to steal, or perhaps the item you wanted to steal was not in the shop. You haven't completed the full physical offence of burglary. That would actually be under section 9(1)(b). But what you have committed at the point of entry is section 9(1)(a), which is really interesting, isn't it? Because you can imagine the difficulties in proving that. How do you prove what is in somebody's state of mind at the time of entry? And the three things that the defendant must have intended to do, these are called ulterior offences. So you may have heard of the phrase ulterior motives. It's like an alternative motive, if you like, something that you don't actually do but you want to do, and that's where this phrase comes from. So these offences are not substantive offences. They are ulterior offences. They do not need to have been completed. It's about the intention to do that upon entry. And when you start practicing application questions in this area, you will see how that looks. But as I say, practically, it's very difficult to prove. And having worked in practice myself, I can recall that the most common type of burglary ever charged was Section 91B, because of course easier for the prosecution to prove. So the difference with 91B is that it covers those more opportunist burglars as well. So you don't have to have entered a property intending to steal or to inflict grievous bodily harm. You can actually decide to steal or decide to inflict grievous bodily harm in the property or the building at the time. So this could cover you go over to a friend's for dinner, having dinner, you go to the toilet, you see an item that you want to steal and you decide to steal at that point. And at that point, you have committed burglary if you go ahead and take that item. But what do they have in common? Both offences have the same actus reus in common. For both offences, you need to have entered a property. The property needs to be classed as a building or part of a building for the purposes of the Theft Act. And you need to have been a trespasser. There are two kind of elements to being a trespasser. You're not just physically a trespasser, but also have the mens rea to be a trespasser as well. And then, of course, if you go on to steal or inflict grievous bodily harm, as is required by Section 91B, you also need to have committed the actus reus of theft or grievous bodily harm. So for theft, you would need to have appropriated property belonging to another. For grievous bodily harm, you would need to have inflicted grievous bodily harm level injuries, so your serious, permanent, substantial injuries that we've looked at previously. So let's have a look at entry first of all. What you will see, similarly to theft really, is that the actus reus elements of burglary are very wide in application. So the up-to-date position on what is required in terms of entry is that entry does not need to be substantial or effective to be satisfied. So we need to have a think about what that looks like. So, I mean, what substantial means to me is that a defendant has gained full physical entry or access into a building or part of a building. So they are in the building. If you want to enter a shop, you actually end up being inside the shop. That would be entry. But you see here, the law is that it doesn't need to be substantial, so we need to look at that. In terms of effective, to me, that would mean you are able to steal or you're able to inflict grievous bodily harm as intended. Your entry is effective. And that principle came initially from the case of Collins in 1972, where the court held that entry must be effective and substantial. That was the Court of Appeal. This is a favourite case of students because it has such bizarre facts, but obviously all of these cases are true. Collins is the main authority on the mens rea for trespassing, because this case actually rested on, in the end, whether Collins was a trespasser or not. I don't think it was ever disputed that he had gained effective and substantial entry. So this involved a 19-year-old defendant convicted of burglary. Section 91A he was convicted of having the intention to rape upon entry. Now, you will have seen that that isn't covered anymore. It's not one of the ulterior offences. And the reason being is because with the introduction of the Sexual Offences Act in 2003, it was felt there was no need to keep this as an offence of burglary. But as it was, this case was in 1972, and the intention to rape whilst or having entered a building as a trespasser was one of the ulterior offences. So the defendant was walking past a house for some reason, unbeknownst to me. There was a ladder that was against the house. And the defendant climbed up that ladder to an open window, saw a woman asleep in her bed. The defendant then descended down the ladder, stripped down to his socks, on, climbed back up the ladder again. It's unknown on the facts whether he was actually in the property at that point. It's believed he was sat on the windowsill, and the woman woke up and, thinking that the defendant was her boyfriend, invited him in, and they started having sexual intercourse. Whilst having sexual intercourse, the woman realised that the defendant wasn't her boyfriend, screamed for him to get out, and the next day he was arrested by the police and charged with burglary. The police felt that rape wasn't the right charge because the act was deemed to have been consensual up until the point that she realised he wasn't her boyfriend. Of course, with our review of consent, there are all kinds of issues there, but it's unclear as to whether he had pretended to be her boyfriend or he just felt that she was inviting him in, having seen him watching her. So it's all a bit vague, really. Anyway, the jury convicted him, but on appeal, his conviction was quashed. And as I say, it wasn't disputed that there was effective and substantial entry. The Court of Appeal was undisputed on that. But they also said the defendant has to have the knowledge, or at least be reckless, as to whether they are a trespasser. And they didn't feel that this was made out because the girl had invited him in. Of course, on the basis he was her boyfriend, but it's not known. The evidence was never clear from both parties about whether this was known. Of course, the defendant said that he didn't know that. He thought he was just being invited in. So there you go. That was the original position. We then go forward a number of years to the case of Brown. This was a defendant who broke a shop window and stuck the top half of his body through the hole, rummaged around inside to steal some items. And this was held not to be substantial entry because, of course, his whole body wasn't physically in the building, but it was effective because he was able to steal. So this, you can see, starts the process of widening the meaning of entry. So it doesn't need to be substantial in this case, but was effective. We then get to Ryan, again a number of years later. And with Ryan here, Ryan was found stuck at an elderly man's home, and his head and right arm was inside the house. He was found by emergency services. So this was not effective and not substantial, but his conviction was still upheld. So what we have, if we think about the evaluation of this element, we have a succession of cases that show the development of the wideness of application in the meaning of entry. It starts off in 1972, needing to be both effective and substantial. We get to 1996, and actually entry can be an attempt, if you like, to enter. It doesn't have to be full entry. So, interesting. Evaluation point there could lead to far more convictions, but of course would make it easier for the prosecution to prove that particular element, which really in practice shouldn't pose too many problems. What is meant by a building? Section 9 subsection 4 doesn't have a definition. It doesn't include a definition in this section, but it does include a list of potential buildings. So a building, Parliament believed, should be an inhabited place. Houses, flats, offices, factories, outbuildings, sheds, your caravans and other inhabited vessels would also be included in that same way. There was a case called B&S against Leithley where the court held that a lorry container used as storage facility for 2 years. The lorry was on sleepers, so it wasn't on wheels, if you like, hadn't moved for a number of years and was connected to the electricity supply. That was deemed to be storage and was deemed to be a building for the purposes of the offence of burglary. The definition of a building comes from the case of Stevens and Gawley. And if you read what it says, a structure of considerable size and intended to be permanent or at least endure for a considerable time. So looking at the case of Leithley, a considerable time would appear to be between 2 and 3 years, if we're going to go by the case law. But you can also enter part of a building and be guilty of burglary as well. And we have 2 cases that give us indication of what a part of a building might be. Part of a building could be in a house. I used my previous example. You go to a friend's house for dinner. Perhaps you're walking past a bedroom and you see an item. You then go into that bedroom and you take it. If we're taking burglary as an entirety, are you entering part of a building as a trespasser if you go into that bedroom and take that item? The law would suggest yes, you may have permission to be at a friend's for dinner, but you may not have permission to go into other rooms of the house. And similarly here, the case of Walkington, a defendant who was shopping in Debenhams department store, reached behind a counter in a till area and took money. And till areas are quite interesting because they're not always physically separated. Sometimes till areas are just on the shop floor amidst clothing and goods and items. And that was exactly the case here. That is why this case went to appeal, because the defendant argued that they weren't in part of a building as a trespasser. They were simply a customer in a shop, if you like. But of course that failed, and part of a building can be a defined till area of a shop. It doesn't have to have a physical separation. Lang, although was not guilty for other reasons, CPS related in the end, this case was important because it defined a stockroom of a shop as part of a building. Defendant went into a stockroom and waited until the store had closed and then was found there. Okay, as a trespasser then, the final actus reus element. So a defendant must know they're a trespasser, or they must be reckless as to whether or not they are entering premises without the other person's consent. That is, of course, hopefully you've identified that as mens rea, knowing or being reckless as to whether you are a trespasser. But what does it mean to be a trespasser? We have leading case, Smith and Jones, if you see, and I'd like you to highlight that in your booklets. Smith and Jones case was really important here. This was a case where a son and his friend had gone to his father's house and taken 2 TVs. Now, even the father in evidence had said that the son and his friend had permission to be in the house. They were both still convicted, and the reason why is because although they had permission, they exceeded that permission. If the father had known why they were in the house at the time, i.e. to steal the TVs, then he wouldn't have given permission. He wouldn't have consented to that permission. So you become a trespasser when you exceed the permission. And interestingly, this could apply to going into a shop intending to steal. You exceed the permission, you become a trespasser. Although if you're caught stealing in a shop, usually, practically, the police would charge theft because it's easier to prove. They don't practically charge a burglary offence for shoplifting, but academically, you could be classed as a trespasser who has entered a building. So there you have it. You identify somebody as a trespasser if they exceed the permission of the owner. Had the owner have known, would they still have allowed that person to enter the building or part of the building? And the defendant must know or be reckless as to whether they are trespassing. That is the mens rea element of the trespasser. And that comes from Collins, knowing or being reckless as to whether they are trespassing. Of course, Collins didn't believe that he was trespassing. He believed he was invited in. So those are the actus reus elements. The mens rea for the two offences. So for section 9(1)(a), mens rea is simply, in addition to, of course, knowing or being reckless as to whether they are a trespasser upon entry, they must have the intention upon entry to commit one of the ulterior offences. Just see if you can think about what those ulterior offences are again. Remember, they are theft, GBH, and criminal damage. Students can get a bit confused as to why criminal damage is an ulterior offence under section 9(1)(a), because of course it doesn't feature under section 9(1)(b). As I say, rape used to be under 9(1)(a) as well, so a number of different offences could have been intended. Try to remember, particularly for OCR law, we do not learn the offence of criminal damage, so it's never going to be a substantive offence that you have to consider in a scenario. So if somebody goes into a building and commits criminal damage, or they damage property, in an OCR scenario, you would not have to consider that law, if you like. If they enter a building wanting to commit criminal damage, they intend to, then you can consider 9(1)(a) here. For 9(1)(b), again, in addition to knowing or being reckless as to whether you're a trespasser, the defendant must have the mens rea for the substantive offence that they have committed, full offence of theft or grievous bodily harm. So let's have a think about what that mens rea is. So for theft, the mens rea elements are dishonesty, according to Ivy, are the actions of the defendant dishonest according to the standards of the ordinary and reasonable person, and does the defendant have the intention to permanently deprive the other of the property? For grievous bodily harm, it doesn't specify, of course, section 20 or 18 intent, so you could say that this could be either or here. Is the defendant malicious? So do they have intention or recklessness to cause some harm whilst in the property, or do they have intention to cause serious harm? Have the specific or the basic intent level for grievous bodily harm there. Now, I think you should take some time to consolidate the elements, write down the law on a sheet or on a mind map so that you've got it all there. Sentencing then, just a word. I mean, you never have to advise about sentencing in an OCR law scenario, but you might be interested to know that the courts or the Sentencing Guidelines Council distinguish between where a burglary has taken place. You have here burglary of a dwelling and burglary of a non-dwelling. I wonder whether anybody is having thoughts about what these are. Essentially, burglary of a dwelling is a residential property, a non-dwelling is a commercial. And look at the year's difference, a maximum sentence. Of course, the courts take burglary of residential properties far more serious, despite, of course, non-dwellings could lead to a higher level of goods, which, of course, is an aggravating factor. Burglary is a triable either way offence, so could be tried in the magistrates or the Crown Court. But if you are charged with your third offence of burglary or aggravated burglary, then this becomes indictable. It's called the three-strike rule. So I'm going to take you through a summary now, but I'll I mentioned aggravated burglary at the beginning under section 10. You can have a look at that offence. It will not be necessary to learn it for the OCR scenarios, but this essentially is committing burglary with a weapon, firearm, or imitation firearm or explosive, having those items or one of those items with you at the time. That would make it aggravated and, of course, increases the sentence. So, burglary. What I'll do is flick through the summary, and any points I want to kind of highlight to you, we'll discuss at the time. So, we've got the two relevant sections at the top. You should always start a scenario or an essay with the key legislation or the key definition, and you break down the elements of the actus reus here. So you see I've got entry, building, trespasser, and the best way to gain maximum marks for application after you've written the first sentence would be to say here what entry is and then apply it to the scenario. So the defendant, or whoever they're called, Joe, has entered the building. It's not substantial, or it's not effective, or it is substantial or effective because you apply to the scenario. The property is a building because it is a house or stockroom, till area, houseboat, caravan, whatever it is in the scenario, you apply that. I've seen some OCR scenarios where they use a caravan, so just make sure you identify what the building is. Joe is a trespasser because they exceed the permission because, and you use what the scenario says, they use the facts. They know or they are reckless as to being a trespasser because, and you apply that. If this is a section 91A scenario, then of course you say what section 91A has or requires. There must be intention upon entry. So these don't need to have been completed. They are ulterior offences. And if a scenario is a section 91A scenario, then you state that and you will gain maximum marks for that. If the scenario covers a section 91B offence, so a defendant goes on to steal or attempts to steal or commit grievous bodily harm or attempts to commit grievous bodily harm, you have to apply the full law. So you will have to go through whether they've been dishonest, whether they've appropriated property belonging to another, whether they have the intention to permanently deprive the other of it. So that part is exactly the same as a theft scenario there. So you apply those elements. If they have committed grievous bodily harm or attempt to commit grievous bodily harm, then of course they must cause or inflict grievous bodily harm or wounding. And you need to identify what the injury is and whether it is grievous bodily harm or whether it is a wounding there. Don't forget that you can make reference to the cases of DPP and Smith and Eisenhower in those definitions too for the actus reus. What is the injury that's been inflicted? And then, of course, you need to make sure that you identify the mens rea for the grievous bodily harm or wounding as well. So do they have the intention to cause serious harm? And look at those key factors that we identified before, such as making prior threats, threatening or bringing a weapon, or have they the intention or recklessness to cause some harm, which is of course the alternative basic level mens rea there. If you can't make out the specific intent under section 18, then it will be the alternative of section 20 if they've caused serious injury. You have to apply those elements and break it down. With OCR newer specification questions, it will most likely be obvious what they want you to apply. A question may well be open, advise so-and-so of their liability for property offences, or they might say specifically for their liability for burglary. So keep an eye out and make sure you are actually answering what is required of you at that point. So in your property booklets, you will have some short application practice, which I'd like you to go on to do. And you can have a look at these, apply the law. There are then some evaluation pointers. You can have a think about these elements and break them down. And then there will be a final application scenario, which is a longer scenario, a 50 marker, that you'll have the opportunity to have a go at later. And what we will do is leave the tutorial now. Your next tutorial will be on robbery in due course. Thank you for listening.